Welcome back, Kent Adams. It's 12:46, and what's the temperature? 20. It's gone down from 28. I hope our lunch meeting that we're going to have after this, I'm having lunch with Ben Stuckert, is not too far from here because it's cold out there. And you've got a short sleeve shirt on, Tom.
I've got
Shrum.
my jacket in the other room.
Okay, yeah. Well, if you notice, I put a sweater on.
Yeah.
I haven't worn a sweater until yesterday and today, and I have the feeling that it's going to continue for a few weeks. Hey, yesterday on my, I think it was Twitter or Facebook, I'm getting the news that the U.S. Supreme Court unanimously really found favor with Samsung, not Apple. Reduce their award and so forth. But talk about and I thought of you because
I wonder why.
we've talked about these kinds of things. So in the next few minutes, let's talk about maybe bring everyone up to date on what happened because
Sure.
I'm not sure everyone followed it. And then what does that mean? Because we always want to know what it means.
So go narrow and bring it back out.
Yeah, exactly.
Okay. So specifically what happened yesterday is the Supreme Court said when you are found to have infringed a design patent, so not a utility patent,
Okay.
when you infringe a design patent, the damages aren't calculated based on the whole product, but on the specific thing related to the one patent you infringed.
Okay.
And
Not
this-
to the overall phone.
In this case, it was 3 design patents. So what this is all about is Apple and Samsung have been fighting up and down, Supreme Court all the way down.
Yeah, Samsung's on fire.
Yeah, pretty much.
Oh,
They've
there's a
been
joke there. Okay.
Yeah.
Yeah.
Well, that's it's not FDA. Jesus,
No,
I
not
can't
FDA.
remember.
That's food.
Yeah.
Yeah.
One of those regulatory agencies is going after FTC.
Okay.
Yeah.
Another government agency.
Yeah.
Yeah.
The one that makes sure things don't blow up when,
Yeah.
when you get on
airplanes at
Yeah.
35,000 feet. Yes.
Right. So Samsung and Apple have been fighting about a bunch of different features
Sure.
that have been in patents back, and it started about 2011.
Okay.
Before then, there was some negotiations. They actually used to be like very closely tied suppliers.
Okay.
And now we've had this long court case.
Okay.
And juries have
They no longer sing in the same room.
not quite.
Yeah. Okay.
So at different times, juries have awarded up to over $1 billion to Apple from Samsung.
That's serious money.
and down to like 120 million.
Oh, okay. Down to 120 million.
Down to.
Sounds like research for a Boeing 747 for the president.
The funny thing about the $120 million award,
Yeah.
in some of the press coverage afterwards, they said, "Oh, that might about cover the attorney's fees."
Yeah. I know. Don't you wish you had that case? Yeah.
Sometimes, sometimes not.
Yeah.
So yeah. Yesterday they decided for the 3 design patents, okay, I'm going to take one step back. So when you are found guilty of patent infringement, one of the things you get is all of the profits from the infringing
Right.
article of manufacture. That's the legal term.
Okay.
And so that's what they were arguing about in this case. What is an article of manufacture?
Okay.
Is it your whole phone, or is it
The
a
design part.
a smaller component? So is
Right.
it just the screen? Is it just, in this case, one of the things they're talking about, the curved edges of the iPhone?
So was the original order for everything? Is that
Yes.
Is that why?
Yes.
Okay.
So originally
the
it
Supreme
was,
Court said no, wait, that's way too large.
and to further contextualize it, each device, so each of these phones,
Yes.
has approximately 250,000 patents.
Of course.
And at issue in this case were 3.
Oh, okay.
So-
so yeah, slightly smaller than the whole.
Right.
Yeah.
So it's not. So the Supreme Court said we have all these tests. You can get a design patent on less than the whole. We have old court cases that say you're not limited to the complete article when you're getting a design patent. So when you're getting the money from a design patent, it should be limited to that what that design patent covers.
Right. Right.
So
Not
that's
not the product as a whole. So-
right. So the Federal Circuit was basically doing a test where it's, okay, I have no idea how to split up how much.
So they threw everything.
Yeah,
Yeah.
and that's what they did at the jury level,
okay.
and that's what they said. The Federal Circuit said,
And the Supreme Court
That's
said,
fine.
not quite.
and the Supreme Court said, no. When you get to this more abstract level,
So what will the amount be? Do you know?
nobody knows.
So what use
It's
is the
just-
Supreme Court if they can't figure that? Oh, they've sent it back, didn't they?
Yeah, they sent it back to the trial.
course.
They sent it back to the trial court. Don't worry. This specific case, and there's a couple other Samsung
course.
versus Apple cases that are, like I said, in the $1 billion
Yeah.
range. This specific case, there was a jury award, went up to the Federal Circuit. They kicked out the jury award, went all the way back down, conducted a whole new trial just on damages. That was the result of this. This went up to the Federal Circuit and then to the Supreme Court, and the Supreme Court said, kick out that whole thing, go all the way back down to the trial court again.
So this is an attorney's employment project.
Basically.
Yeah. Okay.
But I mean,
that's
but then you think about it. This goes to the whole function of the patent system.
right. Right.
And it's
what does it
and
really
the crazy
cover?
and the crazy thing is, what's never been overturned in all these up and downs. Samsung stole Apple's ideas.
Okay.
Samsung saw the iPhone, said, "Oh, those curved edges," and some of the earlier suits were about the slide to unlock.
Like they
and the
wouldn't have
pinch-
thought of those on their
and
own.
the pinch to zoom. It doesn't matter if they would have.
Oh, okay.
Who did it? Who did it first?
Okay.
And those are, I mean, you remember the slide to unlock, and that's an Apple thing.
Ah, okay.
And the iPhone looks cool, and part of what makes it look cool is these rounded edges.
okay.
And so we're trying to reward these companies for doing these innovations.
Right. Right. And then everyone else steals them
everyone else steals them,
with no consequences.
And that's the hard part about this
Okay.
Supreme Court ruling is now, okay, we've got 25.
What's the value of that?
Yeah.
Using those 3 patents.
Yeah, we've built all this stuff into this smartphone. When somebody copies something about the smartphone, let's hit them hard.
Okay.
That's what the
Right.
Federal Circuit was saying.
Right.
Supreme Court was saying, well, you gotta parse it really detailedly
To what the issue is.
to what the issue is.
Right.
And so what's better? So as a value judgment, and that's not what the Supreme Court was doing. But now if you want Congress to jump into this and kind of make some balls and strikes calls, what's the better value judgment? Do you really hammer these people that steal,
Yeah.
or do you really adhere to the like abstract intellectual concept of that particular thing you invented? That's the only thing that should be covered.
Okay, so if someone out there is really as crazy as you about these issues, how do they reach you to ask more questions?
First of all, you can go to McNeiceWheeler.com.
Wow, okay, that's a local law firm.
Hey, we're right out in the valley.
Okay.
Or you can give us a call, 509 928 4141.
Yeah, you stumbled there a little
I did.
bit. Yeah. You almost
I don't have to call myself very
no,
often.
and these days we don't look up things, we push buttons or say,
Yeah.
Siri, please call.
Yeah. Which
Yeah.
is why I always say the website first. Just
Yeah.
double check.
Yeah.
You know? Oh,
Okay.
there.
Tom Shrum, thank you very much. We'll see you probably next week or the week after or sometime
I'm around.
whenever you draw the short straw at McNeice Wheeler, right? And do I really have to go in and see Kent? We're going to take a quick break. We'll be back after this.